Delivery order item 4.
For reasons mentioned in the judgment, this appeal is allowed and the compensation awarded to the appellant is enhanced to rupees 8,43,680.
Document item was 16 and 17, 2 bail matters, my lord. Maybe taken the 2, my lord. I have taken consent from the petition as well. Not at 2, my lord.
Okay.
Look, may I pray for listing a regular first applicant for admission? First time. My lord, to move.
When?
Wednesday, my lord.
3rd August.
My lord, may I pray Wednesday? My lord, out of station. That's why I actually mentioned there is no such urgency because for some days I am out of station.
Okay.
Friday, my lord.
Okay. Friday.
Friday.
I pray for listing of an MFA. There is an IA for delay consideration also. Can it be listed on Friday, madam?
Okay.
Lordship, I beg to mention 2 matters, MAC appeal for settlement for orders column, Lordship.
When?
On Wednesday.
Okay.
My lord, IA has been filed for delay condemnation.
Be louder. Be louder.
IA has been filed for condemnation of delay, my lord. Let it be, my lord, listed on Friday, my lord.
May it please your lordship, I beg to mention item number 10, 12 and 42. Kindly adjourn the matter for the day.
Miss D. Goswami, learned counsel for the appellant. You are for?
Yes, lordship.
Appellant who raised for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant, Mr. R. Goswami. Considering the submissions, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Much obliged.
May I please your lordship, the lordship listing of 2 MSc appeal for order in orders column.
Yes.
Can it be listed on 31?
31.
Highly obliged.
May I please your lordship? Lordship, I beg to mention item number 33. With the consent of other side. Lordship, my senior could not come to the court due to order logging. Kindly adjournment for the day and fixed it
You are for?
next Friday.
You are for?
And Begum,
You are for appellant or respondent?
appellant.
Applicant. And for
36. 36.
no 33.
33.
33.
What is your name?
M. Begum,
Heard Miss M. Become learned counsel for the applicant who prays for an adjournment due to personal difficulty of the conducting counsel. Also heard Miss Hardy Majumdar. Considering the ground the prayer is allowed, let this matter be listed after 31st July.
31st May.
First week of 3rd of August.
Please, lordship. Lordship, with the consent of other side, I beg to mention for listing your lordship. MSc appeal, your lordship. 2 MSc appeal.
Which call?
For settlement, your lordship.
For settlement, when?
On 27/7/2026.
Okay, okay. Allowed.
May I please your lordship? I beg to mention item number 5. As my senior S. Chauhan has sustained an injury in his spinal cord, your lordship, and advice for complete bed rest for a week. Your lordship, kindly adjourn.
You have informed the other side.
No, your lordship.
You have to inform.
Your lordship, will inform. Your lordship, and one more, and my name is inserted wrongly in the in cause list as the counsel of the respondent. Your lordship, it may be corrected.
Heard Miss, what is your name?
B. Chauhan.
Heard Miss B. Chauhan, who prays for an adjournment on the ground that conducting counsel for the appellant,
Appellant, your lordship.
Mr. S. Chauhan, is not well. Considering the ground the prayer is allowed, let this matter be listed after 3 weeks on a date to be fixed by the ministry. Name of B. Chauhan has been wrongly shown in the cause list as engaged counsel for respondent. Same shall be reflected in the cause list as engaged counsel for the appellant by the registry henceforth.
May please your lordship, I have to mention for listing in MSc appeal for enforcement. The matter is pending in last 2020, my lord. So it will come in any day, my lord, on 24 or 25.
Orders column.
My lord,
In orders column,
orders.
24th.
Lordship, I beg to mention item number 6 for an adjournment, your lordship.
Heard Mr. B.J. Mukherjee. Why?
Lordship, some talk of compromise is going on.
Heard Mr. B.J. Mukherjee, learned counsel for the appellant, who prays for an adjournment on the ground that there is a talk of compromise going on between the parties and there is a possibility of reaching an amicable settlement. Considering the ground shown by the appellant, ground shown by the learned counsel, the prayer is allowed. Let this matter be listed after 3 weeks on a date to be fixed by the ministry.
Much okay.
Orders, item 18.
My lord, service is awaited, my lord, on instrument number 4 and 5, my lord.
Heard Miss-
1 to 3.
heard Miss L. Sharma, learned counsel for the appellant. Also heard Mr. R. A. Khan, learned counsel for respondent number 1 to 3. Service is awaited on whom?
4 and 5.
4 and 5.
It appears that the service report in respect of notices issued to respondent number 4 and 5 is awaited. It also appears that long time has lapsed since the notices were issued to aforesaid respondent. Hence, the applicant is directed to take fresh steps for issuance of notice to respondent number 4 and 5 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 24th August.
Achha,
Item 19.
May I please your lordship, I am appearing for the appellant. Lordship, service notice upon respondent number 7 has not been completed, your lordship.
No, you were directed to take steps for paper publication.
Yes, your lordship.
Have you taken steps?
Lordship, I don't have the instruction right now, but lordship,
Hmm.
1 week time may be granted.
If you don't take steps as per direction of the court, then the appeal may be dismissed also.
Yes, your lordship.
What is your name?
As shown on behalf of
Heard
Mr.
Mr. S. Som, appearing on behalf of Mr. S. Datta, learned counsel for the appellant. Learned counsel for the appellant prays for
1 week.
some more time for taking steps for issuance of notice upon respondent number 7 through substituted mode of paper publication. The prayer is allowed. The appellant shall take steps for issuance of notice by publication of the notice in the 2 local newspapers having wide circulation in the address, in the last known address of respondent number 7. The date of appearance to be shown in the notice shall be 24th of August. List thereafter.
Item 20.
Lordship,
My lord, kindly pass over for the time being, my lord.
Why?
My lord, he is taken in
Okay.
oblige.
After.
Item 21.
May please, your lordship. I have stuck between the procedure and the necessity, lordship, here. In 2004, I have filed a petition for probate. After hearing in 2013, that was got dismissed. I have filed an appeal here challenging that probate. During argument hearing, the petitioner executor died, and some of the
Petitioner
respondents
died.
died.
Okay.
Some of the executors brought them, transposed them as a plaintiffs, but after argument hearing, matter was died. We have filed an appeal, but now after on going through that part, lordship, that should not have been filed there. It has to be come on letter of administration part, because no probate to without any executor.
Ah, yes.
During pendency of this probate petition appeal, lordship, my appeal was dismissed. I have filed a petition for restoration here with a petition for delay. And during while the delay petition was pending, reports come that respondents, out of 19 respondents, several has died. Now I have filed several miscases for transposition, but now I have the instruction to withdraw the main appeal, but I cannot go on that line.
So if main appeal is withdrawn, main appeal has been dismissed.
Dismissed for non-prosecution, and I have a petition.
You don't want to pursue this appeal now.
Yes, Lord, sir.
Then withdraw.
With a liberty to go file a petition for letter.
But the appeal has been dismissed for non-prosecution.
Non-prosecution, and a petition is pending. My 203 is pending here.
You withdraw 203. Wait.
Then appeal, if lordship, several other petitions are there, lordships, because
appeal has been already dismissed for default.
Lordship. So that has to be restored, lordship. I need a liberty.
No, but you don't want to pursue.
I need a liberty.
Liberty to
file a petition for letter of administration
before the
district court, lordship. Or after this now 2025 amendments, 213 Indian succession has been deleted. So I may have an option to go for civil suit also.
That clarification we may give in this order.
If that, lordship, my all miscases may be disposed of, lordship.
Instead of
because there are 19 petitioners, out of whom 5 has died. Even one of the petitioner has also died. So that's all the miscases are there, lordship.
2044.
So if that liberty can be granted, lordship, I will be happy, lordship. With the liberty to file a petition of letter of administration or a civil suit, whatever the impact after assessing this.
But is there any limitation for filing letter of administration?
No, earlier it was 3 years.
Now
after the judgment of Honorable Gauhati High Court coordinated bench, when cause of action arose.
So why liberty is required from this court?
Once I have filed the probate petition, lordship.
Okay.
So this period, what I have spent here in the High Court, lordship.
Heard Mr. S.K. Poddar, learned counsel for the.
I'm appearing for DC Nath, lordship.
Learned counsel appearing for Mr. D.C. Nath.
Along with Mr. Chinmay Sharma is with me, lordship. He has signed the wakalatnama.
Learned counsel for the applicants. This interlocutory application.
There are 6 applications, lordship. Total.
Yes.
5 are for substitution. 7. 5 are for substitution, 1 for condonation of delay of the original petition for readmission. And 203 was for readmission.
This interlocutory application. 204 has been filed by the applicants for under Section 5 of the Limitation Act for condoning the delay of 5 days in preferring an application under Order 41, Rule 19. of the Code of Civil Procedure for readmission of miscellaneous first appeal number 37/2013, which was dismissed for non-prosecution on 5/1/2018. Learned counsel for the petition applicants has submitted that the said miscellaneous first appeal within bracket, that is MFA 37/2013, was preferred by the present petitioner, not by present petitioner, predecessor in, by present petitioner who has died.
Appeal has been filed by Dhanesh Das, Vishwanath Kalita, 3.
Who died?
Probate was filed by one Niranjan Kalita, predecessor of the petitioner number 2, who was the executor, appointed executor of the will. But he died during that probate proceeding.
Now, who are these three?
These three are the beneficiaries of the will.
By the present petitioners impugning the judgment dated, which judgment was impugned? Mayfair. अभिषेक एक बार पढ़ो. Thirty 13/8/2012, by which the title suit probate number 10/2005 was dismissed by the Court of Learned District Judge Bombay. The present appellants, the present petitioners were beneficiaries in the will of the will for which probate was sought for. Stop. Learned counsel for the petitioner further submits that during the pendency of the probate title suit probate 10/2025, the executor named in the will,
Niranjan Kalita,
namely Niranjan Kalita, had expired, and
at the stage of argument hearing,
when the suit was pending for argument, where? There.
There, Bongai.
Pending for argument. However, after dismissal of the probate title suit, the present petitioners preferred the connected MFA number 37/2013. Learned counsel for the petitioner submits that on death of the executor, the present petitioner ought to have filed
and
an
separate petition
for issuance of letters of administration or a separate suit. As such, the learned counsel for the petitioner submits that the present petitioners are not inclined to praise the instant interlocutory application as well as also not inclined to for pressing the readmission of the
MFA,
MFA number 37/2013, which was dismissed for default on 5/1/2018. However, he submits that liberty may be granted to the petitioners to seek appropriate relief under law by filing an application for issuance of letters of administration or by filing a separate suit. The prayer is allowed. This interlocutory application is dismissed on withdrawal with the liberty sought for granted. Consequently, the connected interlocutory applications number AG with আছে বাকিবিলাক Abhishek, all numbers so and so, so and so, so and so are also dismissed on withdrawal
in view of this order.
in view of in those IAs as a separate order that in view of the order passed in IA number 204/2021 on so and so date, this interlocutory application is closed.
The earlier order should have been in 203 lots. That is the IA for readmission lots.
No, readmission, no,
No problem.
because it is readmission.
204 is for delay.
Yes,
Yes.
because your delay is dismissed, withdraw. Unless delay is disposed of,
It will
readmission.
serve my purpose, Lord sir. This order will serve my purpose, Lord sir.
Okay.
Oblige, Lord sir.
Item 22.
Item number 22 and 49 lordship. 49 lordship.
Yes.
Both the cases were settled in the last Lok Sabha, but
Settled.
yes, lordship.
My item number 22 and
20 and
49 is
49
the same, my lord. So answering same
29 was settled
experience, my lord.
for additional 3.80 and 49 was settled for 2.
Then why it is before?
Because the other claimants, they have not given no objection also. So now they have given no objection. I filed the affidavit and it is.
Sir, phone किया था मैंने।
Affidavit by the three married sisters. Lord.
Where is the affidavit?
Every last part. Last
Heard
part.
Mr. A.R. Agarwala, learned counsel for the appellants. Appellant, how many appellants?
There are only one appellant and actually there are 4 appellants. So 3 has given no objection for settlement.
Yes, Miss Sharma, you have anything?
It is fixed for hearing, my lord. But
No,
he has
it is
said
for
that
the 22 is your that's 22 is your that's.
that notice case so क्या ना? But in 22, my lord, our name is not on, I think, my lord.
Last time, but sorry. Yes, last time 168.
Appellants. Also Miss L. Sharma, learned counsel for
Behalf of Mr. K.K. Bhatto, my lord.
learned counsel appearing on behalf of Mr. K.K. Bhatto, learned counsel for respondent number New India Assurance,
Yes,
respondent number 3. Mr. A.R. Agarwala, learned counsel for the appellant, submits that this matter was taken up before the Lok Adalat, which was held on
9/5.
9/5/2026, wherein the insurance company amicably settled the matter and agreed to pay an additional amount of rupees 3,80,000 in addition to
Compensation rupees 10,16,000.
compensation amount of rupees 10,16,820, which was granted to the claimants. It appears that when the matter was taken up before Lok Adalat, only appellant number 1 appeared before the Lok Adalat, and other 3 appellants, who are his sisters,
Appellant number 1.
did
sister.
not appear, and therefore it was directed that the matter may be listed before regular court so that the other appellants may submit a no objection certificate, which they have filed today by filing an additional affidavit. On perusal of the additional affidavit filed by the appellants number 2, 3, and 4, it appears that the said appellants have also agreed to the proposal for amendment, proposal for settlement of the instant appeal given by the insurance company in the last Lok Adalat on Nine 5/2026. Who is the counsel? Mr. Bhatto is not
Yes,
there.
Yes,
He has to remain present.
yes. Then, other date may be given, my lord.
Lordship, landlord has
It is
given
better,
consent to him.
But she's not briefed properly. From her submission, it appears she is not aware about. So Mr. Bhatto has to be there.
Other date may be given.
Today he's not. Has he come to court? क्या लिखा last line? (2026). Stop. It appears that in the instant case, the insurance company is represented by Mr. K.K. Bhatto, who is not present today, and on his behalf, Ms. L. Sharma is present before the court. However, this court deems it proper that presence of Mr. K.K. Bhatto would be necessary for disposing of this appeal. As such, let this matter be listed day after tomorrow.
With my lord, item number 49, my lord.
With that,
Analogous matter, my lord.
22nd July with MAC appeal number
196/2021.
196/2021.
that is today item 49.
Number 49.
Item number 49 में लिखना list with MAC appeal number 209/2021 on 22/7.
Item 23.
Yeah, Lordship, this matter is also settled, Lordship. And
For New India.
50/50 liability, New India has settled for 380, Lordship. And other insurance company will have to pay 380 lordship.
Yes, Mr.
As my senior is out of station, so I don't have
Whom you are representing?
as the phone.
Let Mr. Datta come. Heard Mr. A.R. Agarwala, learned counsel for the appellant, who submits that this appeal has also been amicably settled between the parties. However, in the last Lok Adalat, the settlement could not be recorded as the claimant was not present before the court, and therefore it was directed that the appeal may be listed before regular court. Stop. Today, learned counsel for the insurance company, Mr. S. Datta, is not present in the court. Hence, let this matter be listed again on 22nd July.
Item 24.
No, dear Lordship, in this matter, all the respondents have appeared. The matter may be fixed for final hearing, Your Lordship.
Heard Miss C. Fukon.
Madam,
C or P?
Madam, we pray that at least 50% may be deposited. I am the
It is
claim.
already deposited.
Madam, that is my prayer.
50%?
50% of the awarded amount.
Yes. What is to
Kindly
be?
be directed to deposit money.
Is there any stay?
Yes.
Yes, Your Lordship. Lordship,
We'll fix it for final hearing. Instead of taking 50%, take everything. Make your submission. Let us we'll fix a date for final hearing. Heard Miss C.
P. Fukan.
P.
P. Fukan.
P. Fukan, learned counsel for the appellant. Also heard Mr. S. C. Vishwas, appearing for respondent number.
I'm 2 and 3. One.
Respondent number
1 and 3, Madam.
1 and 2.
I'm for claimant and the two claimants, Madam, mother and
Son.
wife one. 2 and 3.
1, 2
Love
and
you, pray. 1, 2.
1, 2 and 3.
Yes, Madam.
Also heard Miss Adi Mujumdar,
1 to 3.
learned counsel for respondent number 4 and 5. It appears that the notice to all the parties is complete and this matter is ready for hearing. Let this matter be listed for hearing. You want a fixed date?
But if you're also a state, then 50% may be deposited. Otherwise, you may pay. At least it will take long time, but it will not come to
Lordship,
23 matter.
Lordship,
In other case, they have settled it matter.
Is there any IA?
Yes, Lordship, there was an I.
Where is the IA? There is no IA. So I'm not staying it.
There is no IA, madam.
Again,
No, I.
No IA is there.
you go for execution.
The early hearing may be fixed.
If possible, first week of the August, madam.
Yes, Lordship.
July, madam.
First week of August. 6th of August. 6th of August. 6th of August.
Available.
Item 25.
Yes.
So this case, there is a delay, my lord,
How much?
of 1249 days.
1249.
Days, my lord. My lord, the petitioner is a illiterate person and a very poor person working from house to house. And she,
Your claim case was dismissed or It is for enhancement.
The case was dismissed, my lord,
Case was dismissed.
and the tribunal cannot dismiss the case like that, my lord, just because of absence of the advocate of the claimant, my lord.
Dismissed for default.
Yes, my lord.
Where is the impugned order?
My lord, the judgment is in Annexure 3, my lord, page 21. Judgment of the tribunal. Yes.
Last audit.
Oh, yes.
No, service complete.
Service को इसको नहीं दो, ऑफिस को तो रख दिया मैं।
वही लास्ट ऑर्डर ही होगा। हाँ, वही 15/6 है ना, जुलाई 6 में था ना।
May I read the? Hello?
No. Before that, whether notice is served to all the respondents. Insurance company is appearing.
No, both the insurance companies have appeared, man.
Who is appearing for 1 and 2? Owner of both the trucks. Heard Mr.
3 and 4 has been deleted, my lord. Respondent number 3 and
2.
2. You have been solved, my lord.
What is your name?
My lord, A. Bhattacharya.
Heard Mr. A. Bhattacharya, learned counsel for the applicants. Also heard Ms. R.D. Majumdar, learned counsel for respondent number.
Opposite party number 5.
Opposite party number 5, as well as Ms. L. Sharma, appearing for opposite party number 6. It appears that notice issued to respondent number Ms. I. Bilakot, opposite party. Notice issued to respond opposite party number 6. 2 has not yet. So, not yet returned. The applicant is therefore directed to. When have you taken steps? No. The registry is directed to place the postal track consignment report of notice issued to respondent number 2 by speed post on the next date fixed. Let this matter be listed. First or second.
File objection, my lord, on Friday, my lord. It may be also taken.
প্রথম 2 সপ্তাহ 3rd of August. The registry shall also tag the written objection filed by the respondent number 6 with this interlocutory application on the next date fixed. List accordingly.
Obliged.
Item 26.
26 Lordship, as per office note dated 17/7/26 Lordship, LCR received, respondent 3 duly served, 4 died. So Lordship, he is the driver, he can be striked out. And for service on 5 and 6 is awaited Lordship. Usual process was taken, so Lordship, now we can take on 5 and 6 instead of waiting Lordship,
Speed post.
speed post.
Heard Ms. R.D. Majumdar, learned counsel for the appellant. It appears that notice issued to respondent number 3 has been duly served. It also appears that respondent number 4 has expired and his death certificate has been enclosed along with the report of the process server. Learned counsel for the appellant submits that since the respondent number 4 is the driver, his name may be strike out from the memo of appeal. The prayer is allowed. It also appears that as regards respondent number 5 and 6, the service report is awaited. Learned counsel for the appellant is directed to take fresh steps for issuance of notice upon respondent number 5 and 6 by speed post within 7 days from the date of this order, returnable on 24th of August.
24 August. Hello, right.
27.
May I please, Your Lordship, in this matter, all the respondents have appeared from 2 to 6, except respondent number 1. 2 to 8 has appeared except respondent number 1. And on the last day, the postal track record was called for, is showing delivered.
This I is for?
Condemnation.
Condemnation of papers.
You are opposing?
No, Your Lordship. Maybe condemn.
Heard Ms. P. Fukun, learned counsel for the applicant. Also heard Mr. R. A. Majumdar, appearing for respondent number 2 to 8. On perusal of the office note dated 16/7/2026, it appears that from the postal track consignment report of notice sent by speed post to the respondent number 1, it appears that same was duly delivered to the addressee. As such, the said notice is held to be duly served on the respondent number 1. Stop, next para. This application under section 5 of the Limitation Act 1963 has been filed by the applicant, that is National Insurance Company Limited, praying for condoning the delay of 100 days in preferring the connected MAC appeal, whereby the judgment and order dated 19/9/2023 passed by the Motor Accident Claims Tribunal in Talgori in MSC case number 5/2018 has been impugned. Learned counsel for the applicant submits that the reason for delay has been stated in paragraph number
3, Lordship. 3, Lordship.
paragraph number 3, 4, 5, 6, 7 and 8 of the instant interlocutory application, and said reasons may be regarded as sufficient cause which prevented the applicant in preferring the connected appeal within the prescribed period of limitation. So, on the other hand, Mr. R. A. Majumdar, the learned counsel for the respondent number 2 to 8, has submitted that considering the grounds stated in the instant interlocutory application by the applicants, the said respondent do not have any objection if the delay of 100 days in preferring the connected appeal is condoned by this court. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. Considering the submissions made by learned counsel for the parties, as well as considering the grounds stated in the instant interlocutory application to be sufficient cause which prevented the present applicant in preferring the connected appeal within the prescribed period of limitation, the delay of 100 days in preferring the connected MAC appeal is hereby condoned, and this interlocutory application is allowed. Stop. The registry is directed to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by list accordingly.
Item 78. Public.
Lordship, I'm sorry to say in this case on respondent number 2, we could not take the steps. Lordship, I may be given only 2 days, Lordship, I'll take the steps.
Ms. R.D. Majumdar, learned counsel for the applicant. Also, Mr. A. Bishwas,
Sorry.
learned counsel for
Sorry.
the opposite party number 1. Learned counsel for the applicant submits that the applicant could not take steps for issuance of notice on respondent number 2 due to some miscommunication, and as such praised for some time for taking steps as was directed by this court. The prayer is allowed. The applicant shall take steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within a week from the date of this order, returnable on 24th August.
Hello.
29.
20.
May I please, your Lordship? I appear on behalf of applicants and A. Alam, Lordship. He is not available. PCR is available. The opposite party is not shown in the law. Cause this, Lordship. I did not see the record, Lordship.
No, service is not complete. Heard Mr. Alamgir,
M. Alamgir.
M. Alamgir, learned counsel, appearing on behalf of Mr. A. Alam,
Lordship.
learned counsel for the appellant. On perusal of the office note dated 14/7/2026, it appears that the notice issued to the sole respondent
30.
30 and 31.
39.
Baba put 9.
What happened? What happened?
LCR has come, but respondent number 4 is not served. We will take step on respondent number 4 also.
My lord, the respondent number 4, wrong address was inserted in the notice, my lord. That is why it was not served.
Okay, do you know the right address, correct address?
Correct address
No,
is
no,
here.
it was a mistake on the part of the clerk, lordship. Some other address is written. Address of the claimant is written.
Oh. Not Mr. A.J. Saikya, learned counsel for the. This is item number?
32.
A.J. Saikya, learned counsel for the appellant. Also heard Mr. K.U. Ahmed, learned counsel for respondent number?
1 to 3.
1, 2, and 3. Learned counsel for the appellants submits that the appellant may be granted one more chance to take fresh steps for issuance of notice upon respondent number 4 by speed post as well as by user mode at his proper address. The prayer is allowed. The appellant shall do so by within 7 days from the date of this order. by speed post as well as by user mode, returnable on 26th of August.
34.
You please. So there is a section 5 application for delay of 771 days in filing of the connected matrimonial appeal. I'm challenging an order dated 26/23 in Misji case 216 arising out of title suit D in 107 2014. I am the respondent therein. I've explained the delay, why it has happened. I am currently working in the Indian Army, and without my knowledge, this impugn order has been passed.
There.
Two.
Respondent number 2 is the owner and driver of the
How much
vehicle.
delay is there?
58 days delay.
You're opposing?
I have no objection.
Heard Miss
P. Sharma.
P. Sharma, learned counsel for the applicant. Also heard Mr. A. I.A. Talukdar, learned counsel for respondent number 1. On perusal of office note dated 16/7/2026, it appears that notice issued to respondent number 2 has been duly served. Stop. Next para. This application under Section 5 of the Limitation Act, 1963, has been referred by the applicant, Oriental Insurance Company Limited, praying for condoning the delay of 58 days in preferring the connected MAC appeal, wherein the judgment and award dated 9/7/2025 passed by the Motor Accident Claims Tribunal, Nagaon, in MSC case number 150/2020 has been impugned. Learned counsel for the applicant submits that the cause for delay in preferring the connected appeal has been stated by the applicant in paragraph number
3 and 4.
3 and 4 of the instant interlocutory application. Learned counsel for the opposite party number 1 submits that considering the grounds shown by the applicant for delay, the respondent number 1 does not have any objection if the delay is condoned by this court. Stop. After considering the submissions made by learned counsel for both the parties, as well as after going through the cause shown in the instant interlocutory application for delay in preferring the connected appeal, this court is of considered opinion that said cause may be regarded as sufficient cause which prevented the present applicant in preferring the connected appeal within the prescribed period of limitation. Stop. As such, the delay of 58 days in preferring the connected appeal is hereby condoned, and this interlocutory application is allowed. The registry shall register the connected MAC appeal and list the same for admission after a week on a date to be fixed by registry.
Yes.
Item 46.
Please, your lordship. In this matter, the PCR was called for, and as shown in the cause list, it has been received. So matter is fixed for hearing, lordship. The matter has already been admitted.
Heard Mr. D. Chaudhary, learned counsel for the appellant. Also heard Mr. S. Rahman, learned counsel for how many respondents are there?
3 respondents are there.
You are appearing for all of them.
2 and yes.
learned counsel for the respondents. This appeal is ready for hearing. As such, let this appeal be listed for hearing after 4 weeks on a date to be fixed by registry.
They want date fixed date.
Fixed date, 8th of October.
Interim order passed.
The interim order shall continue the next day.
37.
The TCR has not been received in this matter.
Yes, my lord.
Miss, what is your name?
You Bihani, lordship.
You Bihani, learned counsel for the appellant. Also heard Mr. A.M.R. Adhikari, learned central government counsel. It appears from office note dated 17/7/2026 that the trial court record has not yet been received. Stop. Issue reminder for the same. Registry to issue the reminder. Let this matter be listed after 4 weeks after receipt of the trial court records. List accordingly.
My lord, similar order may be passed in item number 38 and 39.
You have gone through the office note.
Yes, lordship. TCR records have not been received.
Same order. Mr. Adhikari, you are appearing in both the cases. Same order.
Which obliged.
Item 40.
In this case, Lordship, LCR has come and respondent number others are served, but respondent number 3 could not be served, Lordship, due to improper address. So we will have to take instruction as regard proper address of respondent number 3. 1, 2, and 4 are served, Lordship, and 1, 2, and have appeared already.
Heard Mr. A.J. Saikya, learned counsel for the appellant. Also heard Mr. K.R. Bora, appearing for respondent number
1 and 2.
1 and 2. On perusal of the office note dated 13/5/2026, it appears that notice issued to respondent number 4 has been duly served. However, same is not in the case of respondent number 3, as the addressee could not be traced out. Stop. Learned counsel for the appellant submits that some time may be granted to the appellant to ascertain the proper address of respondent number 3 and thereafter take necessary steps for issuance of notice upon the said respondent by speed post as well as by usual mode. The prayer is allowed. Let this matter be listed again. 26th August.
So your highest dear lordship, stain on the 50% not deposited, which is mandatory.
Lordship, in this case, policy was a bundle policy, but at the time of accident, the OD portion had expired. Only TP portion was valid, and in case of TP case, Lordship, risks of occupants are not covered. That is our contention in this appeal, Lordship.
That is DW already examined, lordship.
We have reduced DW.
And the time court only discussed about this.
Direct, Lordship, we are ready to deposit 50%, but that may not be released, Lordship. That is in step, it is on our prayer.
No, what is your ground?
The policy was a bundle policy, but the
Bundle.
bundle when it includes act policy, both TP and OD. But OD portion was expired at that point.
What is TP? What is OD?
TP means, Lordship, third party, and OD, Lordship, is including vehicle damage, everything, Lordship. But that
While making submissions before the court, you should not use abbreviations unless it is.
Yes.
Okay.
Already discussed, lordship, about this policy. DW was also examined.
Learned trial court was discussed page number 22, Lordship, paragraph 2, judgment note.
Policy is a comprehensive
Covered,
policy.
covered.
Policy was a bundle policy, Lordship, but the own damage portion which covers everything had expired at the time of accident. Only third party was there. In third party, Lordship, there are decisions, various decisions that occupants are not covered. That is our case, Lordship. We are ready to deposit, Lordship, 50%, but that may not be released, Lordship. That is our plan for stay.
Yes.
Lordship. Judgment, trial court judgment, Lordship, paragraph number 22, page number 22, Lordship. Discuss about this. May I read, Lordship?
Yes.
Judgment of the trial court. Page number 22, paragraph number 22 also.
Yes.
May I read, Lordship?
Yes.
Paragraph number 22, page number 22, paragraph number 22. In cross-examination DW1, that is insurance company, clarified that a motorcycle bearing registration number so and so was insured with their company, while policy number so and so is valid from 30/3/2020 to 19/3/2025 for third party, and from 20/3/2020 and 19/3/2021 for first party. He also clarified the
When the accident occurred?
accident is occurred
16/4/2021.
16/4/2021.
Okay.
And he also clarified the OD policy period 1 year was valid from 20/3/2020 to 19/3/21. But OD policy was not renewed with their company after 19/3/2020. In Exhibit A, that is policy, Lordship, the seating capacity of the motorcycle mentioned 2. DW denied that OD policy period 1 year was not valid till 19/3/21, and it was valid till 19/3/2025, Lordship. That was exhibited policy before the learned trial court. An insurance company is liable to pay compensation to the claimant. And also page number 23, paragraph 23, it is further appears that a third party policy was valid from 23/2020 to 19/3/2025 and in Exhibit A, Lordship. Page 23 paragraph number. It is further appears.
There are various decisions, Lordship, that in third party coverage policy, occupants are not covered, Lordship. You have this High Court and Supreme Court also, Lordship. That is our plea in the appeal memo, Lordship. And our contention in the DW in the trial court was also same.
Okay, heard. Mr. A.J. Saika, learned counsel for the applicant. Also heard Mr. K.R. Bora, in I. K.R. Bora, learned counsel for claimant's opposite party. This application under Order 41, Rule 5 of the Code of Civil Procedure has been preferred by the applicant insurance company, ICICI Lombard General Insurance, that is ICICI Lombard General Insurance Company Limited, praying for stay of execution of the impugned judgment and award dated 2/8/2025, passed by the Motor Accident Claims Tribunal Number 1, Kamrup Metro Gauhati, in MAC case number 1858/2021. Learned counsel for the applicant submits that the judgment and award dated 2/8/2025 passed by the Motor Accident Claims Tribunal number 1, Kamrup Metro, Gauhati, in MEC case number 1858/2021 has been impugned in the connected MAC appeal number 49/2026, and said appeal has already been admitted. He therefore submits that during the pendency of the said appeal, the execution of the impugned judgment and award may be stayed. He also submits that though the insurance company is agreeable to deposit 50% of the awarded amount as a condition for grant of stay of the impugned judgment and award. However, same may not be disbursed to the claimant as the claimant was one of the occupant of the offending.
Victim was
Victim was one of the occupant of the offending motorcycle who was not covered under the policy of insurance of the said vehicle. He submits that the own damage policy of the said vehicle expired on page number?
Page number 22. Paragraph 22.
Expired on 19/3/2021, whereas the accident occurred on 16/4/2021. He submits that only the third party, only the insurance coverage as regards third party was valid up to 19/3/2025, and as the victim, this is a death case. The deceased was an occupant of the offending vehicle. He may not be regarded as a third party in this case, and as such, the 50% of the awarded amount which may be deposited by the insurance company may not be disbursed to the claimant. On the other hand, Mr. K.R. Bora submits that
Page number 23, paragraph 23 also.
page number
23,
para
22, 23, judgment of the trial court also.
Lordship, in the IA, it is page 20, Lordship. In IA, it is page 20, Lordship.
क्या लिखा? Submits that the tribunal has considered the rulings of the Apex Court as well as statutory provisions of the contained in Motor Vehicles Act and has held that the deceased was covered under the policy of insurance, and as such, if the stay is granted, stay of impugned judgment and award is granted in this interlocutory application, same may be subject to deposit of 50% of the awarded amount, and same may be disbursed to the claimant. Stop. I have considered the submissions made by learned counsel for both sides. Since the connected appeal has been admitted, hence at what stage appeal is pending?
Lordship.
Appeal.
Yes, Lordship. Orders.
Orders for service.
Service is not.
Upon the owner of the will.
And some time may be required for disposal of the said appeal. The execution of the impugned judgment and award is required to be stayed during the pendency of the connected appeal. As such, this interlocutory application is allowed, and the execution of the impugned judgment and award shall remain stayed during the pendency of the connected MAC appeal number 49/2026, subject to deposit of 50% of the awarded amount by the applicant before the registry of this court within a period of 6 weeks from the date of this order. Stop. Though learned counsel for the applicant has objected to disbursing the said deposited amount to the claimant / this opposite party on the ground that the appeal is likely to be allowed and the award and the deceased may not be regarded as third party so as to get the insurance coverage. However, the contention raised by the appellant needs to be examined, and same can be done only during the hearing of the connected appeal. The apprehension shown by the learned counsel for the applicant may be taken care of by directing the claimant respondent to furnish indemnity bond in the event of dispersal of the said amount, deposited amount to the claimant respondent. As such, in the event the insurance company deposit the 50% of the awarded amount as directed by this court, same shall be disbursed to the claimant respondent on furnishing an indemnity bond of equal value which is deposited by the which may be which is deposited by the insurance company after proper verification. This interrogatory application is accordingly dismissed. Yes.
May I please your lordship? As per office note dated 2026, mediation report has not been received.
What happened in mediation?
Mediation, sir, lordship not settled. 3 times already settled. Mediation case number 120-2026, lordship. Lordship, may be kindly fixed for hearing. Service also completed, alia also received.
Service complete.
Complete, lordship.
You are appearing for?
Respondent number 1 and 2, claimant, lordship.
Heard Ms. P. Sharma, learned counsel for the appellant. Also heard Mr. K. Arbora, learned counsel for the respondent. Respondent number?
1 and 2, lordship.
1 and 2.
Claimant, lordship.
Three.
3 is already struck off, lordship. Driver of the vehicle. Ojoy Eka.
Though mediation report has not yet been received, however, it is submitted.
Mediation.
It is submitted by learned counsel for the respondent that mediation has failed in this case and this appeal is ready for hearing. As such, praise for listing this matter for hearing. The prayer is allowed. Let this matter be listed for hearing on 13th of October.
Highly updated.
Item 41.
Okay.
May please your lordship. My lord, the office note will reveal that, my lord, all the respondents have not only been served, they have also appeared. And your lordship, my lord, on the last occasion, the matter was heard at length. And your lordship, my lord, held that the prayer for stay will be considered only after service of notice on the respondents. Therefore, my prayer is that, my lord, your lordship will fix it for admission, my lord, any day next week.
Next week or first week of August?
My lord, let it be next week. Your lordship knows, my lord, if your lordship remembers, my lord, I have been ousted from the business from my lord February. Although I am a my lord majority holder, your lordship will only hear it. And my lord, all the papers are there in this, my lord, paper book. In fact, my lord, I would have loved to pray for Thursday, my lord, but that I am not praying, my lord. Let it be on Monday or Tuesday next, my lord. My
No,
lord,
we'll
next
fix
Monday
it
appear.
on Thursday.
My lord,
Thursday.
day after tomorrow, my lord.
Next Thursday.
My lord. Can it be Friday?
Which Friday?
Next week, Friday, so 24th.
Next Friday will be difficult.
24th.
Heard Mr. M.K. Chaudhary, the learned senior counsel, assisted by Mr.
M. Sharma, my lord.
M. Sharma, the learned counsel for the petitioners. How many petitioners are there?
2 petitions.
Petitioners. Also heard Mr. B.D. Deka, the learned counsel, appearing for respondent number
126, my lord.
126.
7, my friend.
Also heard Mr. B. Sinha, appearing for respondent number 7 and 8. Only 8 respondents are there.
Yes. Yes, also.
The notice, the service of notice on all respondent No, the appearance of parties is complete in this case. Hence, let this matter be listed for admission hearing on Ukurvare ki Thursday. Thursday you have difficulty.
Yes.
Friday
24th.
20.
24th.
This Friday.
Next Friday. This Friday, I'm sorry.
My lord,
20.
my lord,
Can have it next Thursday also.
that is fine, my lord. Friday is fine for me.
Or
Let it be heard
I
early,
thought
man.
this Thursday. So next Thursday, I guess we can do it.
Tuesday?
Tuesday and
Next Thursday. Thursday.
30th.
30 July. Let this matter
My
be.
lord, the only one difficulty, my lord. Next Thursday, the appeal before the, my lord, appellate form is, my lord, 31st. My lord, there you are. Obliged.
Before trial court, it is fixed when?
31st,
my lord, on the first appellate court.
Or first appellate court.
My lord, they may take a plea that, my lord, tomorrow the matter is being heard, therefore it should not be heard. That's why I wanted a shorter date, my lord.
You would have said
Let
that
it be
even
fine.
today.
Huh?
They can take that plea at any time.
You didn't take it
Tuesday will be good.
My
Next
Tuesday.
Tuesday.
Tuesday, my lord. Tuesday, I will not be in town, my lord.
So Wednesday, my lord.
Wednesday. 29.
Wednesday. Dear.
Obliged. Obliged.
May I please, Your Lordship? Lordship, this is an IA for condonation of delay of 30 days, my lord. For filing review petition.
Heard Miss, what is her name?
P does, my lord.
P does, learned counsel for the applicant. Learned counsel for the petitioner. This learned counsel for the applicant, sorry. This application under section 5 of the Limitation Act has been filed by the applicant praying for condoning the delay of 30 days in preferring the connected review of petition. Issue notice to the respondent. The applicant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 26th of August.
44.
Okay. There is a delay in preparing the appeal.
Heard Mr. A. Bhattacharya, learned counsel for the applicant. This interlocutory application under section 5 of the Limitation Act has been preferred by the applicant insurance company praying for condonation of delay of 148 days in preferring the connected MAC appeal. Let the notice be issued to the opposite parties. The applicant shall take steps for issuance of notice upon the opposite parties by speed post as well as by usual mode within 7 days from the date of this order, returnable on 28th of August.
45.
Like.
May I please, Your Lordship? Lordship, item 45 and 48. Both are analogous and the delay is also
Same.
Separate
order go into common. Similar order, separate order. Heard Mr. D. Mondor, learned counsel for the applicant. This application under section 5 of the Limitation Act 1963 has been preferred by the applicant paying for condoning the delay of 27 days in preferring the connected MAC appeal. Stop. let the notice be issued to the opposite parties. The applicant shall take steps for issuance of notice upon the opposite parties by speed post as well as by usual mode within 7 days from the date of this order, returnable on 28th of August.
Highly obliged.
Same one.
Item 46.
Delay of for 40 days in preparing the
Heard
appeal.
Mr. A. Bhattacharya. Delay of
For 43 days.
443 days. Baki similar order.
My lord, here we are here for enhancement of the compensation. So respond number 2 and 3 may not be required. They may be struck off. Owner and driver.
No, at the first stage, you take steps by speed post. If there is any difficulty, we will struck later on.
Fine.
List 28. একে order হবো?
Apply.
Item 47.
May I please, Lordship? IA for condolence of delay of 22 days, Lordship.
Heard Miss
R. Sultana on behalf of N. Ahmed.
Sultana appearing on behalf of Mr. N. Ahmed. Delay of
22 days.
22 days. Take steps. Returnable on 28th August.
Placed.
Item 51. 51 from 30 days.
Both are analogous matter, my lord.
Your appeal.
Before going to office note dated 77/26, my lord, kindly see office note dated 18/6/24, my lord. The respondent was 6 duly served, my lord, and notice on respondent 2 was received by sister, my lord.
6 served, okay.
Bajaj Alliance, my lord.
18.
18/6/24, 2024, my lord.
Now who remains? 5 only.
Pardon, my lord.
Who remains?
Remains, my lord, five. Other side, respondent number 1 and 2, my lord, assure that they furnish the proper address of respondent number 5, my lord. But they have till the date they have not furnished the address of respondent number 5, my lord. So
Then
some
you
time I needed to.
heard Miss L. Sharma, learned counsel for the appellant, who submits that though the office note dated 17/7/2026 shows that the notice to respondent number 5 and 6 have returned without service. However, she submits that office note dated 18/6/2024 shows that the notice to issued to respondent number 6 has already been duly served. As such, only notice to respondent number 5 remain to be served. She submits that the learned counsel for respondent number 1 and 2 assured the counsel for the appellant that proper address of respondent number 1 and 2, respondent number 5 would be given to them, but same has not been done. As such, some time is prayed for by the learned counsel for the appellant for taking steps for issuance of notice upon respondent number 5. Prayer is allowed. Let this matter be listed again after 26th of August.
52.
None has appeared. None has appeared for the appellant on call. Let this matter be listed after a week on a date to be fixed by registry.
54.
May it pleases your lordship. Lordship, we were directed to take step by newspaper publication, Lordship, on 4 and 5. We had in fact submitted the notifications in the office, Lordship, but due to some transfers in the office, Lordship, of the regional manager, since he was not there, they could not publish the newspaper, Lordship. They could not publish the notice in the newspaper, Lordship. So another order may be given, a new date may be given for appearance, Lordship.
Heard.
Lordship, I am for respondent number 1, 2, and 3. I have not received any notice appeal me till date, Lordship.
Okay.
I will give, Lordship.
But that should be matter of record because
Okay, I have already written.
Heard Miss Adi Majumdar, learned counsel for the appellant. Also heard Mr. A.R. Agarwala, the learned counsel for respondent number 1, 2, and 3, as well as Mr. A.J. Saikia, appearing for respondent number 6. Learned counsel for the appellant submits that though the appellant was directed to take steps for issuance of notice upon respondent number 4 and 5 by substituted mode of publishing the notice in the newspapers. However, due to transfer of some officials in the appellant's company, the steps could not be taken and some time is prayed for the same. The prayer is allowed. The appellant shall take steps for issuance of notice upon respondent number 4 and 5 by substituted mode of publishing the same in one newspaper which is widely circulated.
Vernacular newspaper, Lordship.
Vernacular newspaper which is widely circulated in the last known address of the respondent number 4 and 5. The date of notice to be shown, date of appearance
September,
to be
Lordship.
shown in the said notice shall be 8th of September 2026, list accordingly.
Lordship, my appearance and appeal member, Lordship.
The appellant is directed to furnish memo of appeal along with annexures to the learned counsel for respondent number 1, 2, and 3. Requisite copies of memo of appeal.
I filed one IA for stay vacation, Lordship, without any deposit. The stay has been granted by Lordship.
That will go to the appropriate court, Lordship.
PJ Saikia, Lordship. PJ Saikia, Judge.
Now what do
That should be listed in the proper court.
stay with?
There is order for listing after 4 weeks, Lordship, but it is not listed.
I-28
Order dated 2/5/25. This matter after 4 weeks, but it is not listed.
registry to comply. Heard Mr. A.R. Agarwal, learned counsel for the applicant. Also heard Ms. R.D. Majumdar, learned counsel for the opposite party, as well as Mr. A.J. Saikia, learned counsel for the opposite party number 6. Registry to comply with the order dated 11/5/2026 and release this interlocutory application before appropriate bench.
Obliged.
Item 55.
May I please your lordship? Lordship, as per the office note dated 18/7/26, notice to the respondent number 2 and 3 are duly served, my
How many respondents are there?
lordship.
How many respondents are there?
There are 3 respondents, lordship. Already respondent number 1 have
Heard
appeared.
Mr. M.M. Zaman, learned counsel for the applicant. Also heard Mr. A. Bhattacharya,
appearing on behalf of T. Kolita.
appearing on behalf of Mr. T. Kolita, learned counsel for respondent number 1. On perusal of office note dated 18/7/2026, it appears that the AD card issued to respondent number 2 and 3 along with the notices issued to them have returned with signatures of addressee thereon. As such, notices issued to the aforesaid respondents is held to be duly served. Trial court record. It appears that record of MSC case number 451/2019 have not yet been received from the concerned tribunal. The registry to issue reminder for the same. Let this matter be listed again after receipt of the aforesaid records on 31st August.
Obliged.
Interrupting. Lordship, in this item 54, Lordship, Mr. Agarwal said that he did not receive copy, but in 2024 itself, he has received that line may be struck out. It is not a copy, question of extra copy or no copy. He has received the copy in 24. On 5/11/24, his signature is there. Lordship, that might be striked out.
No, but
If he needs some copy, he can tell me in private, and I told him I wrote it. After that also, he wants it to be written in the order so that he has a time limit for cross objection or something like that, Lordship. That cannot be allowed. Lordship. Then I have
Extra copy.
no, Lordship. It is not a question of extra copy. He has received the copy. I'll submit and let it be part of record.
Yes.
line 2 khati dibo. Last order. However you furnish, I'm not
Issue, Lordship.
I'm not
Yes, it should not be on the.
I'm not reflecting it.
Yes, Lordship.
No problem.
Highly obliged, Lordship.
Item 56.
56, Lordship, office note dated 17/7/27, notices are sent by usual process and speed post and LCR received.
Third Miss R.D. Majumdar, learned counsel for the applicant, learned counsel for the appellant. The records of the motor accident claims case has been received. However, service report in respect of notices issued to the respondent is awaited. Registry is directed to place the postal track consignment report of notices issued to all the respondents by speed post before this court on the next date fixed. Let this matter be listed 21st August.
Tarak Pisot Didyok.
2nd of September.
September.
28th August.
Highly obliged.
Item 57.
Please, Lord. Lordship, we filed this IA for withdrawal of the deposited amount for the registry, which was deposited by the appellant him.
Any objection?
Lordship, we have filed this appeal, Lordship, mainly on the ground that, one of the ground that the deceased was a Lordship pension holder. He died, and therefore, Lordship, one of the ground is that, Lordship, the claimant is getting the claimant had not sustained 100% loss of dependency, Lordship.
Yes, how much? 50% loss.
So I think, Lordship, it's a subject deposit of 3 lakhs will be.
Lordship, the amount is already only 5,25,000, the 50% amount.
50% is we have
We're
deposited.
ready to execute a bond, Your Lordship.
Withdraw, Lordship, 3 lakhs may be allowed to withdraw, Lordship.
No. Let them execute an indemnity bond.
Yes, Your Lordship.
If they are not found entitled, they will return back.
In favor of claimant number 1, Your Lordship.
Heard Mr. S. Sharma. S or R?
S.
S. Sharma, learned counsel for the applicant. Also heard Ms. M. Chaudhary, learned counsel for the insurance company. This application, this interlocutory application has been filed by the claimant applicant, praying for allowing the applicant to withdraw the 50% of the awarded amount deposited by the appellant insurance company in compliance of the order dated 24/10/2025 passed by this court in IA within bracket C number 2690/2025 in MAC appeal number 367/2025. Learned counsel for the insurance company submits that since the claimant is a pension holder, there is the loss of an dependency is not to the extent of 100%. And as such, she submits that only 3 lakhs may be allowed to be disbursed to the claimant out of the deposited amount. However, learned counsel for the applicant submits that it would cause financial hardship to the claimant/applicant and further submits that the claimant applicant is ready to furnish indemnity bond for the amount allowed to be withdrawn by them.
What should the amount may be released in favor of respondent number 1, the wife of the deceased?
Who is Sadiqul?
Sadiqul is the son.
He is the major lordship. He is not considered as a dependent. He is one of the
Okay.
crown lordship.
After considering the submissions made by learned counsel for both sides and going through the averment made in the instant interlocutory application, this interlocutory application is allowed. The registry is directed to disburse the 50% of the awarded amount deposited by the appellant insurance company before it in compliance to the order dated 24/10/2025 passed by this court in IA civil number 2690/2025, subject to furnishing of an indemnity bond by the claimant number 1, namely Amina Begum, to the tune of rupees 5,22,500 after proper verification.
What if the name of Mr. S. K. Goswami has been shown in the cause list? He's not appearing in this case. The name may be deleted. The name is not on the record, Your Lordship.
My name will be wrongly research paper 50.
Okay.
The appeal.
The registry shall not reflect the name of Mr. S. K. Goswami in the cause list as engaged counsel for the appellant henceforth.
Lordship, my name has not been shown.
Yes, ma'am. Lordship, regarding appeal lordship, service regarding appeal lordship, I kindly peruse the office note lordship.
Your name?
Has not been shown in the cause list, Your Lordship.
Whereas name of Mr.
S. Sharma.
S. Sharma may be reflected as engaged counsel for the appellant. Engaged counsel for the claimant respondent. In appeal,
Lordship, as per office note dated 17/7/26, lordship, Answer of notice of respondent number 3 has been received back with postal remark not known. 7 daily, respondent number 7 daily represented lordship. And regarding lordship, respondent number 1, 4, 5, and 6. AD card has not been received back. 1 also there, lordship. Okalat number maybe there, lordship. I don't know. I have not seen that.
Heard Miss M. Chaudhary, learned counsel for the appellant. Also heard Mr. S. Sharma, learned counsel for respondent number.
Respondent number 1 and 3.
2.
1 and 2. 1 and 2, your lordship.
Respondent number 1 and 2, as well as Miss L. Sharma, appearing for respondent number.
Respondent 7.
Respondent number 7.
Sure, others may be a struck off lordship because it's on quantum lordship. The drivers and owners of both the vehicles. The other respondents 3, 4, 5, 6.
Office note dated 17/7/2026 shows that the notice to other respondents are not served. However, learned counsel for the appellant submits that since this appeal is preferred mainly in questioning the quantum of compensation paid to the quantum of compensation payable to the claimant respondent, the presence of respondent number
3, 4, 5, and
3, 4, 5, and 6 may not be necessary in this case, and therefore prays for striking out their name. The prayer is allowed. Let the names of respondent number 3, 4, 5, and 6 be struck out from the memo of appeal. The records of MSC case have been received, hence this matter is ready for hearing. Release this matter after 6 weeks on a date to be fixed by registry.
Maybe. There is a delay of 83 days in preferring the appeal.
Heard Mr. A. Bhattacharya. Delay format 83 days delay, steps logo hat dino. List this matter again on 31st August.
My lord, they have filed execution. So that date is fixed tomorrow. So, can it have shorter date maybe? I'll take steps by both ways.
Short date. 6th August.
Obliged.
So for respondent number 1, I have filed the Okalat number today only.
We'll admit this appeal. Service is complete.
It is only a very small matter, lordship. My case was dismissed on the ground of territorial jurisdiction, which was never raised, neither by 1 nor by 2.
Okay.
No issue was framed on that point, lordship. So my simple prayer will be remand the matter either to pronounce judgment or by exercising lordship's power under 24 own motion, transfer the case to Bajali. At the stage of judgment, lordship, may I take the plea, lordship, lordship to page 26, 25 and 26, lordship.
Yes, Mr. Kolita, what is your submission?
There no objection to that.
Okay, let him make submission first. Yes, yes. Page number?
Page 25, lordship. Upon pleadings, last paragraph. The following issues were framed by one of the learned predecessors of the tribunal to arrive at a just decision. page 26, two issues have been framed. Whether accident took place due to rash and negligent traveling of the vehicle. And issue number 2, whether claimants are entitled to get any relief. Then comes para 9. In order to prove their case, claimant number 1, Kanchan Brahma, examined this and that. Now coming on para 12 and 13, Lordship. Next page 27. Heading was issue number 1. Page 27. Before discussion on issue number 1, discussion in respect of jurisdiction of this tribunal is necessary. Herein, in this case, on the face of the addresses of the parties as well as the place of accident, hence jurisdiction point is not taken up at the outset of the discussion. It is taken up at the outset of the jurisdiction aspect of the tribunal. 166 trial court has discussed. Bare perusal. Then further perusal of the case record. Hence, it is crystal clear that alleged accident as well as the residence of the claimant, OP number 1 is within the jurisdiction of Bajali district, and OP number 2 is having an office at Gauhati. So, according to mandate of 166(2), MBA tribunal has no jurisdiction to entertain the instant claim petition, hence this issue is decided in negative. No issue has been framed on that point, Lordship. No chance was given. Even insurance company have never raised in their WS any territorial jurisdiction point, Lordship. In fact, due to some inadvertence on our part, Lordship, though we are a resident, temporary resident of Barpeta Road, we could not provide that address. Our address was shown as Bajali, Patacharkuchi.
Now, what is the consequence of this dismissal?
That's what, Lordship. So, benevolent provision, Lordship, there are 2-3 judgments I would like to rely on that line, Lordship. Hyper-technical points should not be taken.
No, now whether you can file a fresh claim petition.
No, Lord. That was once it has been gone up to the argument stage, judgment stage, Lordship. One point is remedy that Lordship may direct the trial court, as done by the Honorable Supreme Court in the case of Balbir Batra. I have given here, Lordship. Exactly the similar situation, Lordship. Their residents of Haldwani district, accident took place at Udhamnagar district. Case was filed before Nainital. Ultimately, where the point of territorial jurisdiction was taken, issue framed, learned trial court dismissed on that point, that yes, this court has no territorial jurisdiction, case dismissed. Honorable Gauhati Nainital High Court upheld. Supreme Court says no. As per Malti Sardar and Mantu Sarkar, hyper-technical should not be there. In our case, Lordship, they have not challenged even. Insurance company also in their WS have not raised that part. So my matter may be remanded back.
No, what Supreme Court said ultimately?
Lordship, ultimately is that though taking objection as a lack of territorial jurisdiction before this court first instance, at the earliest opportunity is a condition required to raise objection as important to 21 CPC.
Yes,
Lordship,
suppose that objection has
not been taken. So it is a not lack of inherent jurisdiction. MSCD Barpeta is a purely jurisdictional court. There is a MSCD tribunal, they have the jurisdiction to try MSCD cases, accident cases, Lordship. As per this address part, it should have been tried by the Bajali. That the findings of the learned MSCD Barpeta.
No, my query is what apex court?
So here position has been given, Lordship. Hyper-technical approach in such matters cannot hardly be appreciated. There is no bar to claim petition being filed at a place where the insurance company, which is main contending party in such cases, has its business. Last part is saying, even all these parts, matter was remanded back to Nainital, the trial court, to decide, irrespective of having no jurisdiction.
Why? Because it is
a benevolent provision.
No. Merely because benevolent, because it was not taken at the earliest point of time. The objection was
nobody is going to prejudice, Lordship. That's the only part. Whether any prejudice will be caused.
No, where the Supreme Court remanded back the matter.
31 and 32, Lordship. For all these reasons, we set aside the 32 paragraph, Lordship. Last page. Discussion is at page 31, para 31, Lordship.
No, this hyper-technical approach submission.
Lordship, that part is.
There, the Supreme Court held that since the insurance company has business in that area.
Lordship, that is it. para 11 Lordship. So I have got alternative prayer, that's why Lordship. If my brother on the insurance company says, no, okay, it should be go to Bongaigaon, then my earnest request will be exercising the power under 24 Lordship, CPC, for transfer of the case, setting aside the judgment, transfer to the Bojali jurisdiction. In that event also, I have no objection, Lordship. And
Now, why the judgment will be set aside without there being any defect in the judgment?
Lordship, pardon.
For setting aside the impugned judgment, there has to be some defect in the judgment.
Yes, defect that without framing any issue on jurisdiction, Lordship, court held that, yes, I have no jurisdiction. We have given even no opportunity. Because under 21, territorial jurisdiction objection has to be raised at the earliest, which insurance company has not raised. We have also not raised. Matter went up to argument stage. We adduced evidence, they adduced evidence. Matter up to argument were heard. Suddenly, landed member MSCT, while deciding the issue number 1, which is not related to territorial jurisdiction, decided the issue on that issue, decided the matter on that issue. That is the illegality here, Lordship.
Had you been given opportunity?
No, Lordship. Never.
No, had you been given, suppose.
Then I have the option to under 710.
For
Return of the my claim petition for filing before the proper authority, or I have to approach the Honorable Gauhati Court under 24 for transfer of the petition.
Why at this stage your claim petition was not returned back to you?
The trial court could have done it, Lordship. Somoto trial court could have done it or given an opportunity.
At the argument stage also?
At this, yes, Lordship, no bar. If trial court comes to a conclusion that I have no territorial jurisdiction, then trial court could have given us an opportunity. Either withdraw it, file it a different proper forum. That could have been done by trial court itself. Or trial court could have advised a 710A provision that yes, this court has no jurisdiction.
What is 710?
Return of the plaint. Order 7 Rule 10.
No, after dismissal of the claim petition.
That's why you have to come up for a
No, no, listen to my query.
Right.
After dismissal of the claim petition, it is dismissed on the point of jurisdiction only,
yes,
not on merit.
Yes, Lord.
Not on merit.
Not on.
So, can you now go to the appropriate court, whether res judicata, anything like that will apply?
That's why we are coming before this honorable court
No,
for
no.
setting aside the judgment.
No, no. Without setting aside judgment.
We cannot go, Lord.
Why?
Normally.
Why? Why you can?
Because once a court has decided the case.
It has decided only the question of jurisdiction, that I don't have jurisdiction. By that, it means that you go to the court which has jurisdiction.
They may take the plea that.
What plea?
That it is decided by the court. We have not challenged that part of the judgment.
It has decided.
I'm afraid on that line, Lordship.
You satisfy me.
Yes, Lordship.
It has decided something against which you don't have much to say. You are not saying that this court has, Bongaigaon court has jurisdiction.
Now a case, another part, Lordship, after this new amendment, Lordship, 6 months limitation part. My case will be time barred, Lordship.
Oh, yes.
My case will be time barred here, Lordship. I cannot go now new under, even after the Girikanto Mohanto judgment of Honorable Gauhati High Court. There is no provision for condonation of delay also, Lordship.
Yes, Mr. Sakya.
So far this company is concerned, it has office only at Gauhati. So my concern that the interest of justice, the case may be sent to the
place of accident is within Bojali, Lordship.
We have to pay losses anywhere, in Gauhati also, in Bojali also, in Borkota also. So that will not materially affect us also.
Instead of directing transfer of, you can approach the appropriate tribunal by filing a fresh.
That limitation part will be there, Lordship. 6 months limitation will now under this part there is no provision for continuation of delay part also, Lordship. So my earnest ticket will be set it aside. Either Lordship may direct MSCT Barpeta to dispose it on merit, or to, using the power under 24, Lordship, transfer the case to Bajali, Lordship. From the stage of argument, let the Bajali court decide the case on merit.
Yes, what Supreme Court did in Nainital's case?
That is directed the Tribunal Nainital to decide on merit.
Okay. Heard Mr. S.K. Poddar, learned counsel for the appellants. Also heard Mr. A.J. Sakya, learned counsel for respondent number
2.
2. Also heard Mr. N.K. Kolita, learned counsel for
Respondent number 1.
respondent number 1. This appeal under section 173 of the Motor Vehicles Act 1988 has been filed by the appellants, impugning the judgment and order dated 20/2/2026 passed by the Motor Accident Claims Tribunal Barpeta in MAC case number 377/2021, whereby the claim petition filed by the present appellants under section 166 of the Motor Vehicles Act 1988 was dismissed by the Motor Accident Claims Tribunal Barpeta on the ground of lack of territorial jurisdiction. So, the facts relevant for consideration of the instant appeal, in brief, are that the husband of the present appellant, number 1, namely she, what is the name?
Basparam Brahmo,
Basvaram Brahma,
who is a government teacher.
met with an accident when he was proceeding towards Bagmara Bazaar by riding on his motorcycle for purchasing medicine on 17/5/2021 at about 3 p.m. The accident occurred as the motorcycle which he was riding was hit by a Maruti Alto vehicle bearing registration number AS14L7828, being driven in a rash and negligent manner. Stop. As a result of the accident, the deceased Basvaram Brahmo sustained injuries on his person and died on spot. Stop. After the death of Basvaram Brahmo, the present appellants approached the Motor Accident Claims Tribunal Barpeta by filing an application under section 166 of the Motor Vehicle Act 1988, seeking compensation on account of death of late Basvaram Brahma in a motor vehicular accident. Stop. The said claim case was registered as MAC case number 377/2021. the owner cum driver of the offending vehicle as well as the insurance company contested the claim of the present appellants before the Motor Accident Claims Tribunal by filing the written statement, by filing separate written statements, wherein they denied their liability to compensate the present appellants / claimants. Upon pleadings of the parties, the Motor Accident Claims Tribunal framed following issues. Court issue number 1 and 2 from A at page 26. However, following issues. During the course of the inquiry, the claimant side examined the claimant number 1 as CW1 and 3 other witnesses as CW2, 3, and 4, respectively, and also exhibited certain documents which were marked as Exhibit 1 to Exhibit 16. The owner of the offending vehicle as well as the insurance company adduced no evidence to counter the claim of the claimants. Ultimately, by the judgment and order which has been impugned in this appeal, the Motor Accident Claims Tribunal dismissed the claim of the present appellants mainly on the ground of lack of territorial jurisdiction on the part of the Motor Accident Claims Tribunal Borpeta to inquire into the claim case filed by the present appellant. Mr. S.K. Poddar, the learned counsel for the appellant, submits that though no specific, whether the opposite parties have taken the plea of lack of jurisdiction.
No.
Though in their respective written statements, neither the insurance company nor the owner of the offending vehicle took any specific plea as regards lack of territorial jurisdiction of the Motor Accident Claims Tribunal Borpeta, and no issue was framed to that effect by the Motor Accident Claims Tribunal Borpeta. However, while deciding issue number 1, the tribunal at a belated stage dismissed the claim petition filed by the present applicants on the ground of lack of territorial jurisdiction. I'll dictate rest of the part in chamber. Appeal is allowed. Now, whether I will direct the Bongaigaon or Borpeta or it will be transferred to the which tribunal has the Bojali.
District Judge Bojali as a member.
Whether I will direct Borpeta or will it be transferred to Bojali, you have to wait.
Lordship.
I'll go through that Supreme Court judgment.
Lordship. In similar, our High Court judgment I have given also.
Okay, I'll go through.
That was also Dimahasa and Silchar matter was there, Lordship.
But appeal is disposed of today.
Lordship. Obliged, Lordship.